once again like to welcome all of you to the Indian Publishers Conference 2024's last panel discussion, which is on the topic leveraging the power of copyright and the intellectual property rights in the digital ecosystem. With the proliferation of e-books, the digital subscriptions and the open access resources, the integration of AI and the relevance of the copyright and the IPR protection in the publishing ecosystem needs further reinstated. And now to discuss more about it, we will be having this panel discussion, and the moderator of this panel discussion we have with us Mr. Pranav Gupta. Can we all give a great round of applause, please? Our speakers in this session, we have Mr. Ankit Sahni, who's the partner at Ajay Sahni and Associates. Ms. Pragya Chaturvedi, who's the Intellectual Property Attaché, South Asia Trade Policy Team, British High Commission, New Delhi.
Welcome, sir.
Can we have a great round of applause, please? And our final panelist for this discussion, we have Mr. Saurish Mohan Mitra. Can we once again have a great round of applause? And with that, without further ado, I would now be handing over this session to our moderator, Mr. Pranav Gupta.
Thanks, Nidhi. So once again, I welcome you all to the Indian Publishers Conference. We have a very important subject and a topic of discussion, leveraging the power of copyright and intellectual property rights in the digital ecosystem. As we see, the size of the industry has grown. The relevance of copyright is of immense value for us. Publishing is part of the creative industry, and creativity can be only respected if it can be monetized in a well format. In the publishing industry, there are two important components. One is the authorship, and second is the publishing. It is the author who nurtures the idea, who writes his writings, and it is the publisher who develops, ignifies it, market it, and bring it to the end user. So copyright is of immense value for all of us. Throughout the day, we have been discussing about the unleashing the digital potential with the advent of artificial intelligence, monetization of content in various formats we have been talking about. I think this session becomes very relevant for our audience at this point in time. And I'm absolutely privileged to have a very elite panel with us, starting with Ms. Pragya Chaturvedi, the IP attaché for the South Asia Trade Policy at the British High Commission in New Delhi. We have Mr. Suresh Mitra, the partner at the Gartner with us, and our very own, our FIP Standing Counsel, Mr. Ankit Sahni, a veteran IP lawyer in the India circles. So, we have seen in last couple of years that, publishing and overall all industries have been using a lot of e-commerce to sell their products. At the same time, while dealing with these intermediaries, with the e-commerce forums, the market size for every industry, especially for the publishing industry, has also grown significantly. But at the same time, it has also led into the rampant piracy of counterfeit books. How do you see that the accountability of the intermediaries, and what are the measures that we as a publishing industry should take into the account? And I'll start with Pragya on this.
Thank you Pranav, and thank you first of all to FIP for organizing this brilliant discussion, and thank you for having me here. So on e-commerce platforms and then on combating counterfeiting and piracy, and I'll speak from the perspective of what the UK is doing in this space, as I represent the UK's IP office here in India and in the region. So a lot of action is led by the industry in the UK. So the e-commerce platforms are very active in formulating policies against counterfeiting and piracy on their platforms. But at the same time, they also work with the Intellectual Property Office on dealing with online counterfeiting. So one important piece of work that has been done is this collaboration between these global e-commerce stores like Alibaba, Amazon, eBay, to publish a guidance on protecting IP rights, which has been published on the UK government's website. The IPO has also been over the last few years has been engaging with social media platforms and e-commerce stores, and that includes again Amazon, Twitter, TikTok, Meta, to support their work to protect branded goods as well as digital content, since the focus today is the digital world. We also regularly work with e-commerce stores to deal with counterfeit goods when there is a seasonal increase in counterfeit activity. So that is another piece of work that we have been doing. One more thing I wanted to highlight, and that's still work in progress, but that's not in the UK, but it is led by the UK in the ASEAN region. So our attaches based in the ASEAN region have worked with the 10 different governments within that region to develop a voluntary code of practice that all the e-commerce stores in that region will follow to deal with the counterfeits in that region. So that is one important piece of work, and I think it's very significant in the fight against online counterfeiting and piracy, and that is something that can be also replicated in different regions. Yeah, thank you.
Thanks, Pragya, for that. Suresh, you have been a published author as well, and with your 19 experience as a variety of legal matters you have handled, what's your take on this?
Thank you so much, Pranav, and thank you to the organizers for inviting me. This is a very important area of concern that has been there for quite some time. So, am I?
Yeah, you are audible.
Okay, I'm here. Okay. So when my book was being published, there was a copy that I needed to take out. So to give you an interesting understanding of how people are scared of piracy, so when my book was getting published, I needed to take a printout, and those were COVID times, so it was difficult to find a printer at home or things like that. So I went to a very a shop in a very small market at the basement, went and asked them, can you take a printout of the manuscript? And I just told them, this is just a draft for an examination that I'm about to give, just to hide the fact that this is a book that is going to come out or things like that. So people are really scared about that. And when the actual book got published, and from the entire the process that followed, it was very clear that there is a lot of concern around this. And from the e-commerce websites that we have, earlier they were the places where we could buy the books very comfortably, but at times I have seen the copies which look to be not that original. So I think that in terms of the agreements and making awareness, there has been a lot of improvement since then, and we need to do a lot more in terms of our contracting between the publisher and these online intermediaries, and maybe stronger penalties in the contract to enforce make sure that the legal enforcement can take place, may help in gathering more awareness and reducing this element of piracy that has creeped quite a lot in the industry.
Okay, thanks. Ankit, you have been representing a lot of clients both nationally and internationally, and there have been, a major chunk of revenue comes from their e-commerce sales. So how do you have seen these issues being tackled at the enforcement level, and how they are being dealt in the various courts in India?
I'll start with the problem. The problem is that we had 2011 IT intermediaries rules. Now before that, how the law is designed is that under the Information Technology Act, which is the umbrella law which governs any kind of technology, there is a section called section 79. 79 in very simple terms says that if you are an intermediary meaning it defines intermediary as somebody as a service that doesn't select the receiver of the information or the content or doesn't have actual knowledge of what is being posted. So think of it as, of course, most obvious intermediaries in our case are, everybody knows, Flipkart, Amazon and so on. Other intermediaries could be, YouTube. So anything which is providing an automated system where you can upload something, whether listings for sale or your own song or whatever, that is an intermediary. So law says that for an intermediary, if they don't have knowledge and this is an automated system, they're not selecting the content, the recipient, etc., they will not be liable for what gets posted by the user. It's very simple, because the way Amazon works is there are millions of listings, millions of people selling hundreds and hundreds, thousands of commodities, etc. And eventually, what the manner in which Amazon works is that they will facilitate this and take a certain component as a fee for facilitating the sale of this, but they can't have control or can't be held liable for whatever gets sold. So whatever gets sold basically is the liability of the seller who is selling. But then comes the question that how will the intermediary come into the picture, because eventually the sale of so-called pirated books or other things is actually happening or being facilitated by the intermediary. So then came the provision which basically said, section 79, that upon getting actual knowledge, the intermediary has to disable access to such content which infringes somebody else's right. In 2011 came the rules under this section, and they further clarified and laid down the mechanism in detail. And what the intermediary was supposed to do was, it was supposed to notify the seller that I have received a notice from a right holder who alleges that their copyrighted book is being sold and this is a counterfeit copy, a pirated copy that you're selling. So what is your answer? If the seller was not to answer, the direction under law on the intermediary was that they had to disable access to the content. But if the other person were to reply, then they had the prerogative of either keep the listing as it is or take down the listing from the platform. Now there was in between a very interesting political development in the form of a writ petition that was filed by one individual called Shreya Singhal. Shreya Singhal case was also for intermediaries, but it concerned the posting of political hate speech, one person against another, one party against another. And there also the issue of intermediary liability came, that for Twitter X, if somebody puts hate speech and somebody identifies that this is hate speech, this has been targeted against my party, my people, or against me personally, to what extent is Twitter liable? So the Supreme Court gave a set of directives there, and that got incorporated under the new rules which we have, the 2021 rules. Now under 2021 rules, and this is now what is causing the problem to the commercial side of intermediaries, to us, industries like us that rely on intermediaries to conduct business to a large extent. These rules now say that the intermediary is only liable to take down the infringing content if the information received by them is either through a court order or through an order of some competent government agency. Which means if we were to, as a right holder, give them a notice and say, we believe that this copy of our book titled so-and-so, which we are publishing since so many years, is counterfeit for or pirated for XYZ reasons, there is no obligation or liability on them to either take it down, and there is no repercussion if they do not take it down. So that is the unfortunate state of affairs where we have reached. When we speak and engage with the government, they say, look, we are only bound by what Shreya Singhal judgment has held. The Supreme Court has held and directed in the Shreya Singhal judgment. We have tried to incorporate that into the 2021 rules. The challenge that the industry, not just publishing industry, any industry, FMCG, products, toys, anything, fashion, is facing is that now it has become very expensive and lengthy. Now you have to go to either the law enforcement route, file a criminal complaint, get a magistrate to pass an order and then take the order to the intermediary, or file a civil suit before High Court or before a district court, get an injunction order and then serve that order on the intermediary. So this has made the entire process cumbersome because there is no deterrence on the or repercussion on the intermediary to take, if they don't take action, to take it down. This is the crux of the problem. And after much engagement and feedback from the industry since 2021, what the Honorable Minister has gone on record to promise is that in the new Digital India Act, which will replace the IT Act, the Information Technology Act of 2000, they have promised that they are going to remove this or dilute this intermediary defense or safe harbor, so to say, which is available to a very large extent, so that intermediaries are not able to run free. Earlier in the day we had session on AI, so many sessions where people spoke on AI. The government is also aware of the level to which AI is developed. So they say, why don't you as intermediaries deploy AI? AI is also for you. You have the money as, large tech companies of the world. You have the money to deploy AI-based solutions to come to know if, in an automated manner, come to know if this is something which is suspicious and whether this is something which is a pirated copy or a genuine copy that somebody is selling. Some obvious markers are if the price is too low, if there are spelling mistakes, both in the image as well as in the title, So those are things that an authorized distributor, seller or the publisher themselves will never make. So this is in summary, the problem, and hopefully when we see the Digital India Act come to light, the government does seem to be promising that they will take care of this aspect.
No, very well said, Ankit, and very elaborative one, and I hope the audience would be quite beneficial with this. I'll come back to Pragya. Pragya, you have been working with the UK IP office and closely working with the Indian IP office. How do you see that the UK companies or the global companies in general see the IP regime in India?
Thank you, Pranav, for that question. I think this is this working?
Yes, yes.
Okay. When I joined my current role some 5 years back, this was one of the aspects that we also considered. And we work very closely with the UK India Business Council, which is a government supported body to promote a trade relationship between UK and India, to answer this question. So in their 2021 Ease of Doing Business report, they release this report annually. We included an IP specific survey of UK businesses that had questions around the perception of UK businesses of India's IP regime, if they had any issues with it, or if things have changed in the last few years. When we got the results from that survey back, an overwhelming majority of UK businesses said that they were generally very happy with how the rights granting system in the Indian IP office was functioning, and there were some minor areas for improvement, and this is, I'm talking back in 2021, and we all have seen the tremendous transformation that has taken place since then within the Indian IP office on streamlining the IP rights granting services, having these stakeholder consultation sessions, the open house sessions that Dr. Pandit was earlier referring to. So this perception about the ease of getting IP rights registered, that has only strengthened, and in my interactions with the UK businesses also, they have mentioned to me that in the recent years it has become much more easier. It takes less time, way less time than it used to take earlier. And even from my perspective, I used to work with the Indian IP office many years back, and I have seen backlogs dating back to 10 years, which is now, I think, almost immediate. You can get a copyright registered within 2 months, a trademark within 3 to 4 months, and a patent within 2.5 years, which is very close to the global standard. So we have seen this significant progress in the last few years. One area where we have been working very closely with Indian stakeholders as well as UK stakeholders, including the Indian government, is IP enforcement. So that has also strengthened over the years. We have seen separate IP divisions within the high courts for faster disposal of IP cases, specialized IP crime units within some state governments, police departments. That is an area where I feel more collaboration, more best practice exchange will help businesses from both the countries. So that is where we are continuing our collaboration.
Thanks, Pragya, on that. Mr. Mitra, you have been working with a large multinational consulting group, and of course, you must be working with both large Indian, corporates as well as the multinational corporates investing in the Indian markets. How do you see them looking at the IP regime of the India?
This is a very interesting question, and I'll go back to my initial days of practice when I started off with real estate, but then IP was a very upcoming area at that time, and there was a couple of law firms who were specialized in that. Now the team I used to work under, the partner suddenly decided one day that we will do IP from now onwards. Very nice. So then I was given the opportunity to do that. But you imagine a new area that's like today, like say data protection. Nobody knows much what the rules are, things are, but all coming up. So IP was very much there, but the enforcement, the way, and it was not known. So I was tasked the responsibility of doing all of that. So then I had to run pillar to post actually to find out what the process is how to go about it. Then I found out some lawyer in senior from my law school who had started practice on her own. She helped me to understand how to do that. I actually happened to stick those trademarks, photographs of that onto a piece of paper, put that into a file, and I still have that file. And as Ms. Pragya mentioned, it took 18 months at a minimum to even get that processed.
Wow.
So from those days, manual filing being everything to today the way it is, we've been able to enforce a few very quick judgments in my previous organization, which helped us to enforce our rights. Change has been definitely very encouraging. There is no area in law or in practice which cannot be improved or will not have areas of scope of improvement. But in the case of IP, the shift that I've seen from the beginning of my career till today is really very encouraging, and I feel that it has a vast opportunity to go ahead and make India a place where IP is looked upon as a good area of practice and where companies can safely and securely get their marks in place.
Okay, thanks, Mr. Mitra. Ankit, you have been an IP practitioner here in India, and both at the judiciary and plus doing a public policy work around that. How do you see the IP regime in the European Union? You have been there on the various committees of the Indo-European Union, Indo-UK, and you have been even representing the Indian clients there at the US. How do you see the IP regime in US, UK, European Union vis-a-vis with the Indian regime?
I think I will say two things. One is, there's been a very marked cultural difference, obviously also with the history of both the regions, the Indian subcontinent and European Union and the US. The thing is, they have always been the givers, or before 2014 when the present government came, a lot of the industrial or trade policies were very socialistic in nature. So the impression that people had of India was that if you get your IP here, वो तो मतलब फ्री में लेकर गवर्नमेंट उसको 10 लोगों में बांट देगी, because they don't want to innovate themselves, they want to get the innovation and the creativity and the content from different countries, उसको लेके यहाँ पे बांट देंगे, and the remnants or some of the provisions that remain as a big big needle in the arm that still stick out include what we have discussed previously at this forum as well, which is section 52(1)(I), in the name of education, blanket exception to allow anybody to loot the hard work of publishers, of authors without being accountable, and that to people, entities who are carrying out commercial activities. Today education is only on paper, not for profit. Not for profit doesn't mean people are not earning salaries. They are not buying cars, there isn't infrastructure, they don't have offices to sit in, all of that is happening. Not for profit is only the structure of, so in the name of education, and then coaching institutes which are not even meant to be not for profit, they're definitely and openly for profit, to allow all of these categories of people in the industry and schools, colleges, universities, private coaching, to photocopy books that are being made with years and years, career worth of hard work by both the authors as well as publishers, is the biggest sign of the past policy that previous governments in this country have run. It is unfortunate, although we have been trying and the government has been, earlier I was fortunate to hear Dr. Pandit, who has been trying and has been a friend of the publishing industry. So we've been in a constant engagement with them since 2021, the standing committee report and recommendations, which for the first time included in India's history the fact that this exception needs to change, be watered down, if not removed, and we are now engaged with the government. It's a long process to bring in amendment. So the point is, they've always seen the past policies of India, Indian governments that have remained in administration in the past as very socialistic. Their intellectual property is respected as a commercial right. It is as important as teaching children in the class that if you cannot steal, you cannot also steal somebody's essay. You cannot steal what somebody has invented. You cannot steal somebody's drawing. If a child is very good in drawing in a classroom, it doesn't mean you click a picture or you just copy what he has done and you take it home. That education or those values are being inculcated by them at the very grassroots level, which need to be replicated here because our values have changed. India has become a leader today, and India is giving the world much of creativity, much of technology, much of content, as opposed to merely being a back-end office of receiving content, publishing it at cheap prices and doing that. So there, the thing is, enforcement is a top-notch priority, and enforcement is conducted swiftly, which is why a lot of publishing houses here, whose origins are from outside of India, or a lot of other businesses, they're very upset at how long it takes for people to enforce. Now, see, the difference is with, I was hearing Pragya's views, and very nice to hear another government, which is a very close partner of India, a very close ally, give such feedback that, and which is true, I can corroborate and double that, by saying that it is, as a practitioner, taking now only 3 months, 4 months for a copyright to get registered, and 8, 10 months maybe maximum to get a trademark registered, and so on, which took very long. Same feedback Sorish gave. But the point is, that is the part that lies in the government's kitty. The government is trying to do what they can. Enforcement is something which lies in the judiciary's kitty. And the question to ask is, of course, it is improper, but also it is not in my mouth to speak and say what is the judiciary doing today. But somebody has to raise this question and ask if judiciary has actually caught up at the same pace in the name of independence of judiciary, whether we've been able to catch up at the same pace by letting them govern themselves as quickly or as efficiently as the government systems have improved, everything has gone digital and so on. That unfortunately hasn't happened, but in other jurisdictions that isn't the case. Whether it is the police or it is the courts, enforcement happens swiftly, quickly, and every time I meet, have the privilege of meeting in my office or otherwise anybody, whoever comes, never comes with a happy story. Obviously always comes that infringement is happening, this is happening, and whenever we give any solution, the first feedback is this is either a very expensive solution or a very time consuming one. And this is something that the government has to understand, or the judiciary has to take forward, and these are basically the differences, and this is what I feel, observing the cultural differences and perhaps the remnants of the previous governments that we've had, the value system that we had here, that is kind of creating a problem.
So Ankit, you mentioned about the Parliament Standing Committee. I just wanted to quickly understand from you that, see, intellectual property, IP, copyright, these are very technical things, very technical subject which every layman doesn't understand. When you were before the Parliament Standing Committee making the suggestions for the various industry and the reforms needed, how do you perceive that the people there at the top post, top institute, constitutional post, that they are understanding this issue and how they are addressing it?
Do you want an honest answer? Or
I want an honest answer.
Okay, so the honest answer is, see, they were at that point in time 51 members of parliament, some of whom were ministers and some of whom were leaders of opposition, even leader of the house and so on. I mean, now without taking names, the thing is, across parties, the problem is because culturally intellectual property has not been given that much of importance. I have unfortunately heard people at the level of cabinet ministers saying that gyan ki chori nahi hai. So if having assumed such an office, if that is the perspective that somebody has, it's not something that we should pick up a fight over or criticize. Or the idea is we must step into their shoes and understand what is the experience that they have had. They have perhaps never seen intellectual property and industries that ace at intellectual property like the publishing industry with that much of importance. So I feel, the answer is, or the solution is, it is our responsibility. Let's shoulder the responsibility of taking all the resources that you invest in making, publishing, industry reports, all the wonderful reports and the data, for instance, the Nielsen, book report and so on. Take that data, number one, to highlight the government how important we are in terms of how much employment we are generating for the country, how much GST we are contributing to in terms of purchasing. Right now, naturally, there's no GST on sale of books, but in terms of input, that we pay and which we can't set off. So on and so forth. And what is the direct impact on the Indian economy if Gyan ki chori is allowed to continue in terms of people pirating books, circulating them on Telegram, on WhatsApp and so on, and openly, and then the courts or the law enforcement agencies not being able to take action against them because there are some parts of the law that allow something like this to happen. So it is now, the onus is on us. Coming back to the standing committee, it was a mixed bag. Naturally, there were some people who had really prepared well. They were very supportive, again, regardless of what party it was. They were very supportive of our submissions, the publishing industry and the recommendations that we made with your instructions. But others did not understand, and they said, अगर कोई काउंटरफीट बना रहा है, कोई पायरेटेड कॉपी बना रहा है, तो आप देखिए साहब, उसमें मेरे एरिया में अगर कहीं पर एक गढ़ है, मुझे पता है वहाँ पे बुक्स पब्लिश हो रही हैं, तो वहाँ के लोगों को एम्प्लॉयमेंट मिल रही है, चाहे वो नकली किताब, और नकली किताब पढ़ के कोई बीमार थोड़ी होता है, वो मतलब गोली टॉफ़ी की तरह थोड़ी है, या कॉस्मेटिक आइटम की तरह की लगा के कोई बीमार हो जाएगा. दे फील कि नॉलेज ही तो हम बांट रहे हैं, एम्प्लॉयमेंट जनरेट हो रही है, तो क्या हार्म है. सो दिस सेंसिटाइजेशन इज रिक्वायर्ड.
ज्ञान की चोरी,
नॉट डिप्लोमेटिक.
सो ज्ञान की चोरी चोरी नहीं है. सो आई जंप टू मिस्टर मित्रा, एज यू आर पब्लिश्ड ऑथर, एंड in the morning also we were discussing about, you know, in India, if we compare, authorship is not considered as a profession. Authorship is something where people write more for out of passion. If I vis-a-vis compare it with the Western world, where authorship itself is a profession, they make good amount of royalties and their livelihood survives on that. Do you think, as a published author and being an IP practitioner, and the conversation what we are having from last couple of minutes, that respect for the copyright, respect for the intellectual property needs to be done right at the school level? Should we inculcate that into our curriculum? What's your views on that?
You're absolutely right. So when I got the offer for the book, and the amount seemed to be decent enough in terms of royalties and things, and the engagement with the publisher was very nice. So I happened to call up somebody whom I knew, who was the publisher of a teenage magazine called Target many years back. So I knew the publisher, and I used to love her, so I was connected with her. I called her. She's now a publisher of children's books. So I called her to understand that now that I've got this and I love to write, and I've written many articles and there are more books I want to write, can I switch to this as a full-time thing? She said, don't ever even think of doing that, because that's not something that is ever possible, at least in the current circumstances. So she told me, you focus on your book, congratulations, you got that offer, but don't leave your job. Because I thought that, you know, preparing a book and writing all about it is a full-time affair, and I need to kind of move away from that. But she told me, no, once your book gets published, and only if you are established and you sell lots of copies, then maybe you have a chance to make it a full-time author, and then possibly you can think of leaving a job or whatever you're doing as your main profession. So coming to your question with respect to this habit of, from a very ground level or from a very foundation level, whether it should be passed on, it definitely should be. We never had, when we were in school at least, I don't remember anybody ever encouraging us to write for the sake of making that a profession. We were told stories of Ruskin Bond, we were told stories of many other great authors, O. Henry, etc., but never with the intention that you will become one. The focus is always on other regular careers that we have, like science, medicine, even law also wasn't a career at that time. That was very well articulated. In today's times, when I see, and I'm actually a career counselor with a few schools as well, and I do go back and teach in law school. So over there, the scene has changed significantly. They are encouraging a lot of opportunities for the senior students from 9 to 10, and they invite experts in that area to come and speak. So while I was taking care of the legal area, I did find someone who had come in from from an authorship perspective, and we were both doing it together in one such session, where this exact question came up, that can a child who is now here ever dream of becoming a full-time paid author and be satisfied? And the other person who was with me actually raised the same point, that if in the school curriculum itself there is a focus on Gyan ki chori na ho, that what is yours, don't take anybody else's, but create your things and ensure that that gets published. that is when the things will change. So it should be some kind of teaching there as part of the curriculum itself, which will inculcate the habit in someone that what you are creating is what is yours. Like for scientific things, it's always says that you get a patent done. That is still very popular. That people know that you have a scientific invention, you can have that patented. But for books and things like that, that is still, I think, far behind, and maybe a change. Hopefully with our new national education policy, things may change if it is enforced in the way it is supposed to be done.
Thanks, Mr. Mitra, on that. So, Pragya, quick comment from you on this. And further, is there any initiatives on these lines by the UK IP office or the Publishers Association UK or the CMO operating there, like Copyright Licensing Agency?
Thank you for that question, Pranav. So in the UK, this awareness building on IP and having IP as a component of educational activity, that is considered very much part of the enforcement pillar, because it's important to develop that respect for IP within the students, within general public, so that they are not only aware of their IP rights, but they also learn how to respect other people's IP rights. So the IPO has been committed to working towards building a situation where infringement is seen as socially unacceptable by everyone, and that is very much part of the building greater respect for IP initiative. In 2022, the IPO released a counter-infringement strategy, again focused on dealing with IP infringement, and that reaffirmed the government's commitment to working with different stakeholders on awareness and education campaigns. So the IPO works very closely with industry stakeholders on these awareness campaigns tailored to different audiences. It also works closely with consumers on making them aware about IP infringement, and just to make sure they don't unknowingly also get involved in any kind of IP infringing activity. We regularly work with industry stakeholders on a lot of awareness campaigns focused around infringement. Then there is also the enforcement awareness campaign, which is specifically laid out within the counter-infringement strategy, and that has two pillars to it. One is to develop an evidence base focused on consumer research to develop even more impactful campaigns. And then another one is to help consumers understand what constitutes IP crime, especially in the digital world, in this era of internet, to make sure that they don't take part in infringing activity. We were also talking about the pirate websites like Sci-Hub, for example. So in the UK, there's a dedicated IP crime unit. It's part of the City of London Police. It's called the Police IP Crime Unit. It is funded by the IP Office of the UK. Its activities are supported by the IP Office, and its objectives are laid down and supported by the counter-infringement strategy. It's called PIPCO in short. So PIPCO also works very closely on online enforcement, and they have also issued notices making it very clear that even accessing Sci-Hub is illegal. I mean, even as a student or as a researcher, even if you're accessing the website, that is illegal. So that is a big part of their activities there. Coming to building this IP awareness in the education curriculum, so IPO has a separate research and education wing. They work very closely with schools right from the primary level to build IP awareness into the school curriculum. So that is one key part of their activity. Then IPO has also developed free tools on IP education that are free for anyone to access.
That's good.
So these tools are for creating IP awareness generally, from students, between students from schools to colleges and universities. And then there are also tools which are specifically meant for IP educators to help them introduce IP as part of their curriculum, irrespective of which course they're teaching. So that is very much within the mandate of the research and education wing. Another initiative is the online copyright infringement tracker. So IPO, every year it commissions independent research into the online infringing activity that is taking place to better inform the policy against infringement. And we have been working with other countries also to, work along similar lines. So yeah, that's a brief overview of what the IPO is doing in this space.
So that's a lot of things, the initiatives, what I could see at the UK IPO level, office level have been doing in UK. Do you think there is a possibility or synergy that through UK IPO office we can leverage something from the IRRO with our bilateral partner with CLA or FIP along with the Publishers Association UK to bring such best practices, content, some model workshops to be done here, and possibly a lot of school publishers are here. They can adopt as a model textbooks or a model as a role model content which can go and disseminate to the schools. That will be helpful for the publishing industry here.
Yeah, definitely, Pranav. So, our mandate is to work bilaterally with the Government of India on policy issues that are of benefit to both UK businesses and Indian businesses. So, it's all about mutual benefit and learning from each other. So, we have been working with some stakeholders on exchanging these best practices in different policy areas. We have done a lot of work with the music industry, for example, and I'm very much open to working with the publishing industry stakeholders on these awareness workshops, policy dialogues, and a best practice exchange that can benefit businesses from both the countries. So yeah, definitely, I'm very much on board with that.
I'm sure Dr. Gupta and Mr. Mittal will be reaching out soon to you on this for this. And you also brought a very interesting, during the conversation you mentioned about this Sahib Lebjan case, which I would, my question would be to all three of you, and I would like to start with Ankit on that. The Sahib Lebjan case has been a global case. A pirate site itself, it claims it's written on their website. Number of ex-parte injunctions and orders were given in the international jurisdictions, right from the US, Canada, many countries in the European Union. And Sahib Lebjan never came in front, came forward to contest these cases in the international jurisdictions. Similarly, some of our Western publishers, international publishers, chose to file another injunction before the Delhi High Court here in India, somewhere around December 2019. The case is still pending yet. And for the first time, Sahib has come forward and is contesting this case on the pretext of one is fair use and the other provisions made in the law. Is it something that the Indian copyright law is too weak to defend such cases vis-a-vis with the international jurisdictions? Your take, Ankit, on that, and I would like to have a comment from both of you.
Thank you, Pranav. So I think this is the other follow-up after the DU photocopy case. And when people realized that DU photocopy case has led to a conclusion where anybody can openly photocopy in the name of education, teacher and a pupil during the course of instruction with no qualificatory conditions mentioned therein, such as that it has to be regulated university or educational institution. It should not extend to private institutes where students are paying lakhs of rupees as fee, but they don't want to buy books which are worth hundreds of rupees. All of these things are not there. After the judgment came, everybody thought that in India they can come and do anything. And it is very unfortunate that because of the precedent that got set in the DU photocopy case, people have felt, especially Sahib Lebjan, that there is India is the ideal jurisdiction for these things to be contested, and for us to get, in the name of free speech, freedom of speech and information and so on, and in the name of getting free content for whatever you may call underprivileged, this, that. I mean, if somebody were to ask them, what section of the society are you representing and who has asked you to represent? Where is the proof that you are representing the underprivileged or anything? They don't have anything to do. So it's very unfortunate that India became the first jurisdiction and remains the only jurisdiction where they decided to enter appearance. This lady, and we realized she was a lady behind this initiative only after they entered appearance here. So she used to be anonymous. They never used to enter appearance. An ex-parte injunction used to happen and take down the website in other countries. Eventually, they entered appearance here. We came to know it's a lady because they filed a defense. And they are contesting it. And because they are contesting it since 2019, it pains me to say that the publishers who have initiated this have not been able to, in over 5 years, obtain even a temporary injunction against Sahib. When Mark, very obviously the cases between the facts between due photocopy case and Sahib case are different. Due photocopy case, the photocopier was present within the vicinity of Delhi University in North Campus, right, within the vicinity of colleges of the North Campus. Sahib is a site where, I don't know, hosted where, Croatia or somewhere, or maybe Sweden or somewhere.
It keeps saying, it
Yes,
keeps saying. It's
and-
Russia, Ukraine, and
Yes, and so they cannot even prove that they have any legitimate basis to connect the complete cover-to-cover scanned PDFs of so many of Indian publishers' books that we have seen in our.
they themselves admit that they are the pirates.
Yes, and they openly.
And they
admit
work on
that
the
they are
donations.
pirates, They are pirates. So again, the question goes back to my previous comment that the case is not before the government. It is the judiciary that is the right body to take action. And it is before the Delhi. So as regards the decision of contesting it before the Delhi High Court, I mean, I've advised officially IRR and FIP on this. My personal take on this is that if I was strategizing to file a case, I would try some other High Court. See, filing a case before Delhi High Court is like banging your head against the wall. There is already a 2-judge bench decision in the due photocopy case which is against us. So why do you want to, when there are 22 high courts in the country, why do you want to start from Delhi High Court again? Because even if one judge agrees with you, that judge's judgment in the first instance will be set aside because there is already a 2-judge bench judgment of the Delhi High Court against this. Then if you are even further lucky, when you reach a 2-judge bench, if that 2-judge bench disagrees with the previous 2-judge bench, then by procedure they will be required to refer it to either a 3-judge bench or a 5-judge bench. This process itself would have taken at least 5 to 6 years. Right now, from 2019 to 2023, you are still before the single judge and you have not been able to get even a temporary injunction. This is a very disturbing trend, and this is what is deterring. I mean, what we should bear in mind is it's not just publishers who are keeping this in mind. You know, the report and some of the data with your, your blessings, the Federation's blessings that I could carry and based our arguments on, for instance, before the standing committee or even in court, wherever we've intervened, has disclosed that there are foreign publishers, not taking names, which have said that we are now deliberately, or even Indian publishers, so overseas publishers that are saying we are now deliberately only sharing license of previous editions of books. 5 editions prior, 3 editions prior. So what is happening is, we must bear in mind, what is happening is, now take the example of say engineering, mechanical engineering. Some person who's reading, a leading book on engineering, some Indian student in an Indian engineering university, college, he is reading a book which is 3 editions old. Because the publisher outside has said no point in sending new books to India, they just get pirated and nothing happens in court. So he or she is reading 3 editions old book, and they are now competing in the global job market after graduating and getting a BTech degree with knowledge, armed with knowledge which is 3 editions old. And students from the region, from other Southeast Asian countries, even South Asian countries, this situation is not the same, let me assure you, in Sri Lanka even, or even in Bangladesh. We enforce our clients' rights in Bangladesh, in Sri Lanka as much as we do in India, and the situation is very different there. So if you're going to be competing in a global job marketplace, reading a book which is 3 editions old, how do you expect an Indian student to outshine a student from another jurisdiction? This is the level at which it is impacting Indian economy, Indian citizens, and obviously Indian publishers and the publishing industry as a whole. So this is unfortunately, the impact or the situation that this has led us in. I feel in terms of strategy, if FIP were to ever intervene, or some other publisher or publishers who find that their books have been photocopied cover to cover, if they were to decide to intervene in this, better strategy would be to file a separate lawsuit and try another high court, because it's so simple. Even if one high court in the entire country, one bench, agrees with our argument, another high court will not be bound by a 2-judge bench of Delhi High Court. So let's say if we take this matter to Bombay High Court, where you can file a petition straight away. Other states you have to start from district court. So let's say if we take this to Bombay High Court, even if a single judge agrees with our case as is presented and issues an injunction, that injunction will be binding, and what they've been trying to achieve in 5 years here, one order will be able to achieve that in 1 day of hearing, where they'll be able to take down Sayab and Libgen and put a stop to that. That is what is required, but some initiative is required from the industry's end to take this ahead, especially somebody who has noticed that their titles are uploaded there cover to cover in PDF format, free for anyone and everyone to download and print and so on.
So, Mr. Mitra, your take on that?
I think I would wholeheartedly agree with what Mr. Ankit has mentioned. He has extensive experience in this area, and while we ourselves are in a position of being impacted by it, if a proper step is taken under the law, if one high court is not able to do that because of a precedent that has been set, why not try out with any other high court which may give us a favorable response? So a favorable judgment can help to it will obviously not eradicate everything, but it will be a stepping stone to ensure that there's the people who actually carry out these activities, the offenders, they are put at warning that what you're going to do is not going to be accepted and you're going to be impacted. So there has to be some reason why they're doing it, and most likely it's a commercial reason for it. So that if that commercial reason is attacked and closed, then the probability of them continuing with an activity which does not lead to a commercial gain will obviously deter them from doing these activities. So the enforcement has to be in such a way that the root cause is hit at, and basically, in my opinion, it is the commercial part of it. What a normal author gets by publishing, by copying that and putting that into the public forum, somebody is gaining somewhere. And as Mr. Ankit mentioned, that if that impacts the readers, or it impacts the persons who are going to consume that knowledge in terms of good books, in terms of knowledgeable books, that is something that is very disheartening to hear. So from an enforcement perspective, I think what we should focus on is more from a commercial angle. Another angle that becomes very important in these kind of situations is how does the awareness bit hit. We've seen a lot of campaigns, a lot of advertisements which takes place across the industry when popular programs take place or popular sporting events take place. Like there's obviously a lot of focus on smoking. When we are watching a movie, the first ad comes is that smoking leads to cancer. If such a campaign can be done, I'm not sure who will bear the cost for that. It again boils down to cost. But if such a national campaign can be done to sensitize people that what is being done is wrong, I think that will have a larger impact in creating that awareness. So my twofold explanation would be first to hit at the root cause, take the money angle out of it completely and starve them of the means to do the copying and the pirated publications, and secondly create that awareness saying that what is being done is wrong, refrain from publishing things. We've seen a very good example in the last 1 year, I would say. There's somebody called Food Farmer who suddenly has become a sensation across our country because he happened to highlight something that was critical for our living. He highlighted that the way the labels are being done across the industry is absolutely wrong, and we are not reading those labels because of which things are being consumed which should not be. We are consuming wrong things, we are consuming things which are not claiming to be what they actually are, which are they're claiming to be but they are not actually there. So I would like to conclude that a similar kind of awareness can be created, and if one individual on his own money can do it, I think if we have an industry body who can push this, the impact will be much greater. Thank you, sir.
Thanks, Mr. Mitra, on that. So I'll take one quick question on this. In today's time, like in almost all majority of the sessions, we have been talking about AI. And as we move forward, authors, content writers, publishers will be using and embracing the AI. And a lot of new content would be generated. And there would be times when X amount, X percentage of content is originally written by an individual, and with the help of machine learning or AI tool, there is altogether a new content is being generated. My question is, under these circumstances, who should be given the credit as an author? Whether it has to be just the prompt engineer or the person himself who has done that. That's one. Second, under the current regime of the law, the copyright is valid for life plus 60 years. Do you think that it should remain the same, or the tenure for this copyright for the life plus 60 years should be brought down? I'll start with Ankit on this, and then I'll take a quick comments from both of you.
I will just mention 2 points as per law, not as per what I feel. As per law today, these are open questions for most jurisdictions, including UK. I would love to hear what Pragya has to say on what's happening there. But in India, 2 things that I can talk about are under Section 2D6, Indian Copyright Act. Since the 1990s, there was an amendment that happened. It inserted Section 2D6. It says in the case of a computer-generated work, that is the words that it uses. In case of a computer-generated work, the author will be the person causing it to be generated. So which means 2 things. One, that computer-generated works are protected in India. Number 2, it is the person who is causing the work to be created that gets to nominate himself or herself as the author. There is no indication, on the contrary, the entire scheme of the Act doesn't allow for a non-human to be made an author in the present form that the Act exists. So that was one thing. The other quick thing was, I want to draw light to the Honorable MOS Commerce's statement in February this year, made before Parliament in response to a START question, which was also, given its importance, was also published through PIB, Press Information Bureau, by the government. He clarified that the government's position is, as of now, the government of India understands the importance of AI and takes the stand, wishes to protect AI-generated works as copyrighted works, as works that can be granted copyright protection. And number 2, as far as text and data mining or training is concerned, there he mentioned that if an AI tool, large language model, gets trained on somebody's copyrighted work, it will be dealt with in the manner which is contained in the Act, indicating that if you don't have license, you will be liable for infringement if you make commercial use of somebody's copyrighted material to train your AI.
Thanks. Pragya, a quick comment from you.
So Pranav, in the UK also, there are kind of similar provisions on computer-generated works, like Ankit said. Any computer-generated work with a human involvement, that is protected for 50 years from the end of the calendar year in which it was generated. And in the last few years, because of the ongoing discussions around the interface between AI and IP, the UK IP also did 2 rounds of consultations, open consultations on this interface, and it mostly focused on copyright and a bit on patents. But one important question was, of authorship, of the term of protection, and the second was on limitations and exceptions. So these 2 were extensive consultations. The UK IP received a lot of feedback from different sets of stakeholders. The government considered those responses, analyzed them, and then published its own responses to these stakeholder submissions that we received. But ultimately, the decision for now that was taken is that these provisions around computer-generated works, they will remain the same. There will be no change to that, and there has not been enough evolution to consider, granting authorship to any AI-generated works, for that matter, because it's still very much a developing area, and we need a lot more evidence and a lot more consultation before coming up with a definitive policy on that. So that is the current position that we have in the UK on this interface between AI and IP.
Thanks, Pragya, for that. So I had a couple of more questions, but considering the time limit I have, and my president sir has been telling me, so we'll close this session. But I must say, as and when the industry grows, copyright is of immense value. It is one of the most important assets for us as the industry. And I really look forward, Mr. Mitra, to come join us at Indian Reprographic Rights Organization as an author. Pragya will be keep engaging with you and will keep you busy in terms of strategic collaborations with the Publishers Association UK, CLA UK, and through your UK IP office. And Mr. Ankit will keep bothering you for all our IP issues, both at the federation level and the Indian reprographic level. So thank you so much. Thank you so much for the esteemed panelists for joining in today, and I'm really grateful. And very soon we'll be having amongst us Shri Harsh Malhotra ji, the Honorable Minister of State for Corporate Affairs and Road Transport and Highways. He's on his way to start with the awards function for today's evening. So we'll be looking forward for him. Thank you so much.
I would also like to thank all our panelists on stage and our moderator for sharing with us their meticulous research on such a brilliant topic of copyright and intellectual property rights also. And now I will be taking the opportunity to invite on stage Mr. Ramesh Mittal and Mr. Ashok Gupta sir to kindly felicitate our panelists on stage. So can we all please give a great round of applause for our first speaker that we have, Mr. Ankit Sahni. Our next speaker, Ms. Pragya Chaturvedi. Our next panelist, we have Mr. Saurish Mohan Mitra. And our moderator for this incredible session, Mr. Pranav Gupta. I once again thank all of you for your invaluable contribution to this conference and enriching it with your wisdom and insights. And moving along, we have successfully concluded all our panel discussions.